Thanks for offering to help me out with this. I have a really interesting new case that you can help me with. You're going to get some really good experience. It's going to help your career path. So we represent Charles Cook and his company, Cook Enterprises. He's a great guy and you're going to love him. He's been my client for years. He's super smart. He's actually a lawyer too, but he doesn't really actively practice except to, work on his own business.
What does he do?
So he developed a high-end timekeeping and billing program called TimePro, and it's for attorneys. It's really revolutionary, it's high-end, it's a great program, but that's the problem. It's too good, and that's how this litigation all started.
What litigation?
So Charles used to work for a company called Prism, and now they're claiming that Charles stole the technology for TimePro from them. So they've brought this claim for misappropriation of trade secrets against him. So Prism's represented by Bill Dye, and Bill is really aggressive. But the good thing is I've dealt with him before, and I just know that we just definitely have to be on our toes. But that's okay. I mean, there's no merit to Prism's claims from what we've seen so far. Also, Charles has a strong claim that Prism breached his contract when it terminated him. I'll get you a copy of his contract and a draft of the claim that I prepared, but the contract requires a 10-day written notice to Prism's CEO before we can sue. We haven't decided yet whether we're going to include it in the counterclaim or if we're going to file a new suit, but I'll make that call. For now, can you just draft the pre-suit notice for me to review, put it on my letterhead to Prism's CEO, and once that 10-day notice period is satisfied, then we will file it. And we may also need to add a whistleblower claim, actually. It was really brazen what Prism did. I mean, they fired Charles right after he exposed some illegal business practices, so.
All right, so you want me to write a letter? Do you want me to CC anyone in particular on the letter?
No, I'll handle the appropriate CCs. Just get me a draft notice and I'll take it from there. But, there are a lot of other things that I need you to focus on.
Okay, so what else can I do?
Well, here's a list of some current and former employees of Cook Enterprises. We think maybe witnesses. We have a manager, a few technicians, and a former technician. I'd like you to call all of them and let them know that Bill Dye may be trying to contact them and that they shouldn't say a thing about this case to anyone. I'm especially worried about this former employee. He's disgruntled and he may have an axe to grind, so the sooner the better. Please put together some brief talking points and I'll review them with you before you call them. And also, as soon as we tighten up any leaks that we may have on our end, we need to focus on gathering evidence. Charles gave me a list of people that he used to work with at Prism, so he's given us some names. It looks like he flagged the CFO, the director of IT, a former vice president, and I think an engineer and some low-level employees who probably didn't have anything to do with this, but they may have seen a thing or two. So they may have some interesting things to say, but I want to get to those people before Bill Dye does. He'll get his claws into them and we need to get to them first. So trust me, if we wait for depositions, we'll get nothing but evasive answers, obstructionist tactics, and I'm sure we can get a lot of really great information on the trade secret claim. So if we confirm that Charles was right about the Prism illegal conduct, then we may even be able to get them to drop the lawsuit on the bogus trade secret claims and just, they can avoid all the consequences of their illegal criminal conduct.
All right, are you sure all this is okay? It just doesn't sit quite right with me.
I don't see a problem with any of this. This is how high stakes litigation works, especially with someone like Bill Dye on the other side. My biggest concern is whether any of the people that Charles knew at Prism will even talk to you. Try to not sound like an attorney. Charles said, they like to go out for drinks at the bar across the street, so maybe you can go over there on a Friday and just sit up there and see if you'll bump into anyone and, just try to talk to them. And worst comes to worst, if we have to, we can try to use our paralegal to make contact instead. I mean, just coach her up, and if all else fails, then we can ask Charles to reach out to them directly. If we don't have to get involved in that sense, then great. I think he's still on good terms with a few of them, and I think that they would talk to him.
I don't know. Would you mind if I took sort of a refresher on the bar rules first?
I don't know why you'd have to do that. I've been practicing since you were a toddler, and I just told you it's fine. But sure, go ahead. Maybe I overlooked something. Let me know what you find, but make it quick.
All right, sounds good.
Oh, hey, Adam, before I forget, I have a separate question I could also use your help on. I was just approached by a potential new client who's being sued by a vendor over a dispute in payment terms. They hired a different law firm to handle the litigation, but they're new to litigation and they're not sure how it's being handled. They asked if we could take another look at the pleadings and give them a second opinion as to how the other firm is doing and whether they've raised the appropriate affirmative defenses. So I'll email you the case number. Will you please pull the pleadings and let me know your thoughts? So yeah, I mean, we'll talk on Friday again, and let me know if you have any questions in the meantime.